Okay, CC students, we're on video 3. We're all in the corona quarantine. I do not have the coronavirus. I do have a mark on my forehead. That's only because I was wearing a hat and I went for a run, and it's a beautiful day outside, although we are all going crazy. Today is Wednesday, March 24th, 2020. Had to check the date. Hope you all are staying healthy. We're seeing your comments on the videos. I appreciate those. And again, if you have questions, feel free to do that. We'll check Facebook to see if anybody wants to do online meetings. Maybe we can do that through Zoom. But on another note, we're moving forward here. Rules of evidence, part 3, objections. In part 2, we talked about what objections, what they are, right? We named those. We went through the various types of objections that are used in the CC mock trial packet. So that was in part 2. Part 3 now, we're going to talk about the how to do this objections. And before we do that, though, let's go over what the purposes are. Purpose of objection in real trials is to, on the record, we want something established so that if we want to appeal the case, the outcome did not go our way, we want an appellate court, like the Superior Court or the Supreme Court in Pennsylvania, to make a decision about what occurred on that case based on our objection. We want that to be part of the record, that we objected to that. In this case, though, in mock trial, we're not appealing this to the Superior or Supreme Court. Our rules, our purpose really is to prevent testimony or protect the witness. So let's start with protecting the witness first. How would you use this to protect the witness? Well, let's say, and we know because of video 2 we talked about, one objection is asked and answered. Let's say that you're the prosecution and the defense is now asking the witness on cross-examination the same question over and over again. And your witness has answered the question. As the prosecution, you're trying to protect your witness because the question's been asked over and over again. Same time, same question, same answer, same question, same answer. And it could be, isn't it true that you were drinking and driving? Yes. Isn't it true you were drinking and driving? Yes. So then you were drunk and you were driving? Yes. Okay, that question now has been asked 3 times. Same answer, asked and answered. So as the prosecution, I'm going to say, we object, and we're trying to object because the question has been answered. So we're trying to protect the witness. We don't want the witness to continue to be badgered. The other thing we can use an objection to do is to prevent testimony. Let's say there's some type of testimony like improper character testimony. That's an objection. And we don't want that testimony to come in during the trial. So we would object to the testimony that's being offered by the witness because we're trying to prevent that testimony from coming in. You'll see a lot of these are just based on staying awake and making sure we pay attention. So that's our purpose. How do we do this? Well, we want to present this to the judge. So really, we're raising an objection and we're asking the judge to make a ruling for us. We're going to present it to the judge. And the procedures that we use to do this are very simple. Opposing attorney hears the question, and my note to you is to stay awake. So let's say, for example, the prosecution calls their first witness, and the first witness is a police officer. And they say, isn't it true, officer, that you have been a police officer for 22 years? Or you've been a police officer for 22 years, haven't you? Correct? Both of those are leading questions, okay? They suggest the answer in the question. And you know by now, based on all these videos, that in direct examination, we don't ask leading questions. Instead, we ask open-ended direct questions like, how long have you been a police officer? Or better than that is, where are you employed? How long have you been employed? And you allow the witness to offer that testimony. So in the direct examination, the prosecution is saying these leading questions. Isn't it true you've been a police officer for 22 years? Okay. The defense hears that question, and ding, 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 they go, oh my goodness, that's a leading question. Improper. So they stand up and they say, they stand and they speak, and they say, I object, Your Honor. And now we're going to offer the reason for our objection. In this case, you know I've said leading. The other side is given, it says response by the other side. Sorry for the glare. Response by the other side. So in this case, our prosecutor who asked the leading question, defense raised an objection, judge should give the prosecution a chance to respond. They could say why they believe this question is not leading. Okay? The judge then is going to make a decision, and there's 3 ways that the judge can rule, and my patent pending traffic light is what we're going to use to remember this. The first, the judge says sustained. When you hear the word sustained, you should think stop. Sustained, stop. Remember, prosecutor asked a leading question. Defense says, objection, Your Honor, leading. Judge says sustained. That means that question cannot go forward. The witness cannot answer it. The prosecution cannot ask that question. Sustained, stopped. Red light. The judge may overrule the objection. And if you hear overruled, that means go forward. Green light. And the judge may also then take it under advisement. And that is what I would say a yellow light. Use caution. So the judge is not going to sustain the objection and say stop. The judge is not going to overrule the objection and say go ahead. The judge is going to take it under advisement, meaning you're going on treacherous grounds. The ice is getting thin, attorney. I recognize the other side made an objection, and I could sustain it, but I'm going to tell you to be careful, and you better clean up your questions, because if you continue down this road, the next few questions and they raise an objection, it's going to be sustained. So sometimes judges just say, I'm going to allow this, but be careful, because asking this officer these questions this way, leading on direct examination, is improper. I'm going to give you a little latitude because it's a mock trial, but you better start asking some open-ended, direct questions going on forward, so it's taken under advisement. And everybody's like, what do I do? And this happens all the time in mock trials, so you should practice this. You remember, sustained, stopped. Stop. You can't ask that question. Overruled? Go ahead. You're allowed to. And so what do you do as an attorney? Now the prosecutor has asked that question. Defense objects to it. The judge says overruled. Well, that means then you can ask the question. By this point now, there's been a lot of chatter going on. Your witness doesn't remember the question. You don't remember the question. You look down at your notes and you ask the question again. That's proper. That's how you deal with that. Here's some advice for you. We should use courtesy. We should be gentlemen and women while we're doing this, because there is part of advocacy in being a litigator in trials is treating the other side with respect. Even though we're in a battle, you should be courteous to the other side. So allow the other side, you raise your objection, allow the other side to answer. Don't make faces. Don't respond to the other side. This is like debate, right? You're addressing your objection to the judge. You're giving your response to the judge, and the judge is speaking to you. You're never speaking back and forth in court like that. Don't disagree with the judge. The worst thing you can do is the judge says, other side says objection, the judge says sustained, and you say, and you throw a temper tantrum. That's not going to work. Don't do that. In fact, here's my advice for you. If the other side objects, act like you anticipated that happening. It's like not a big deal, and just move forward. We'll work on some of those in questioning on how to do that. Hold on. Okay, sorry for the delay. I had to turn the heater off there because that was going to be distracting, and I don't want to stop this video because we're 8.5 minutes in. The judge overrules. If the judge overrules an objection, it doesn't necessarily mean they disagree with you, but they want things to be heard. They want to hear. So on that objection about the leading, just because they overruled that doesn't mean that you were wrong. You were right that the prosecution was asking a leading question. The judge overruled your objection. The judge is allowing the other side to ask questions because they want to hear the question. They want to hear the answer, okay? Here's the other tip. Work out objections in advance, okay? I would say you should work out your objections in the point that you should anticipate the questions that are going to raise a hearsay objection. So if there's a chance, for example, here's one. We talked about this in the hearsay exceptions in video 2. If you don't know what I'm talking about, when you're done here, go back and watch that again. One exception to the hearsay rule was the defendant's own words. So let's say you ask a witness what the defendant said, and the other side says objection hearsay. You should anticipate when you ask that question that the other side is going to object to hearsay, so you need to be prepared. How are you going to respond to that objection? Okay? So anticipate that. Anticipate opinion testimony. In your mock trial, you have 2 experts that are going to offer expertise opinion, expert opinion based on their training and experience. Anticipate that the other side's going to raise an objection to the opinion testimony and how you're going to deal with that. Okay? Prepare to use this to block testimony. So if you know there's testimony that's unfavorable to your case, prepare your objection to use that to block testimony. Another point, one member should not do all of the objections. So you should divide those up. Maybe you want one attorney to focus on one witness, but I would recommend that anybody who hears something that they feel is objectionable, that they should do that. But don't overdo it. We'll get into that. The other thing, this is cut off, but it says not during opening and closing. Our mock trial rules say that you shouldn't object. You can't object during opening and closing. Now, here's another thing. I was just showing this to my class today when we met online. So I will use this again when we get into our examining witnesses, especially dealing with expert witnesses. But I want you to see something as I work out my questions. And this is how I do it in real life. I have my name for my police officer. I know what they're going to say. I also I want to talk about their training and their basically any kind of college, police officer standard training they went through, their certification, their specialized training. I'm also going to talk about their experience, their prior investigations that they've done. I'm also going to talk about anytime, I would use this in drug cases where I had drug experts. I would talk about any time that they have testified as an expert previously. Maybe in your mock trial you have an expert who's testified previously. I would put this in my initial question so I know what I'm going to ask. Then I'm going to use, remember we talked about this in direct, we're going to drop them in the case. I want to draw your attention to an exhibit or something that happened where you're working as a police officer on this date. And I use this in my examples before. Also, you may have them identify the defendant. I would always have one of my witnesses identify the defendant. You may or may not do this in the mock trial, but here I show in my notes where I want to do that. I also list out my exhibits. So if I'm going to have an exhibit, literally, here's what I would write. I've had marked as exhibit number 2. What is this exhibit? So as I'm working through my trial, and this is kind of my trial outline guide as I work through my witnesses, this is my outline. When I get to that exhibit, I have it marked. This is where I'm going to ask about the exhibit. In my head, I'm thinking about, have I established a proper foundation for this exhibit? Is there any possible objections that could be raised? I'm working through that in my head before I even get in the courtroom, and I'm ready for that. And that's what we're talking about, anticipating the objections, being prepared for them, so that when they are raised, you've already worked those out in your head and you're ready for a response. So that's fine. We'll go through this again in another video. I just wanted to bring that up. And again, really proud of my handy-dandy traffic light. I don't know about the rest of you, but it's getting stir-crazy being at home. Well, what am I talking about? You guys are home all the time. So it's probably stir-crazy for my family that I'm home. Thanks for watching. Hope this was helpful. I've got another Rules of Evidence Part 4 coming up. Stay safe and wash your hands. Thanks.